On behalf of the Institute for Innovation in Prosecution, I want to thank you for joining our virtual panel on prosecutor-led diversion. This panel is following last month's release of a series of papers on prosecutor-led diversion that was recently published in the Criminal Law Practitioner. The series was made possible by the generous support of Arnold Ventures. You can read the series of papers on our website, prosecution.org. On our website, you can also find our newly released trauma-informed prosecution training and our latest publication, Prosecutorial Culture Change, a primer. On September 23rd, we'll be hosting another panel on crime survivors. Also, be on the lookout for our upcoming procedural justice training curriculum. To find out more about the latest news at the IIP, please follow our socials at IIP_JJ8Y. We invite you to send questions throughout today's panel. You can click the Q&A function at the bottom of your screen to send your questions directly to the host. Before we begin our panel, I'd like to read our land acknowledgement statement, honoring both the land and culture of Indigenous people across the country. We want to acknowledge that the IIP is based in New York City, which is Lenape-Hoking, the Lenape homeland. We honor all of the Indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of Indigenous peoples. We also acknowledge the enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon the Indigenous communities and people of color across the country, which inspires our ongoing work. Thank you, and I'd now like to turn it over to our director, Michael Kahn.
Thank you so much, Michelle, and thank you to the entire IIP team for organizing this discussion, and thank you to all of our panelists for joining us today. This conversation is remarkably timely as the COVID-19 pandemic and renewed urgency around decarceration and racial injustice has forced a long-awaited reckoning for our criminal justice system. Meeting these challenges and issues requires critical assessment of alternatives to incarcerations as we look to end the use of prison sentences as a default response to many offenses. Diversion, particularly innovative and scalable programs which address underlying causes of crime and do not shy away from serious offenses, offers an opportunity to meaningfully and humanely reduce the adverse impact of the criminal legal system and imbue it with human dignity. While diversion is by no means a cure-all, it's a powerful tool that prosecutors must employ to shrink the carceral footprint. To dig into these issues, I am pleased to bring together such forward-thinking visionaries. I'd now like to introduce our panelists. DA Beth McCann was elected District Attorney of Denver in November 2016 and was sworn into office on January 10th, 2017. She is the first female district attorney in Denver's history. Beth brings extensive prosecutorial, legal, and managerial experience, proven leadership, and community perspective to the Denver DA's office. Immediately prior to becoming district attorney, McCann was the four-term state representative for House District 8 in Central and Northeast Denver. McCann was a leader in criminal justice matters and healthcare reform throughout her legislative career. She began her legal career as a law clerk for Colorado's U.S. District Court Judge Sherman G. Feinsilver. She then served almost 8 years as a deputy and then chief deputy district attorney in Denver, prosecuting hundreds of cases, including child abuse and murders. McCann was Denver's first female manager of safety in the early 90s under Mayor Wellington Webb and the first director of Denver's Safe City program to help kids stay out of gangs, drugs, and violence. Juvenile crime decreased by over 20% following the establishment of this program. Next, Courtney Oliva is Executive Director of the Center on the Administration of Criminal Law at NYU. Before joining NYU, Oliva served for several years as an Assistant United States Attorney in the District of New Jersey and a Special Assistant Attorney General with the New York State Office of the Attorney General. In these capacities, Oliva investigated and prosecuted a variety of federal and state crimes, including violent crime and drug offenses, theft of government funds, endangerment, criminal negligent homicide, and grand larceny schemes designed to defraud the New York State Medicaid program. Prior to becoming a prosecutor, Oliva spent several years in private practice representing individual and corporate clients in government, regulatory, and internal investigations and security litigations. Kent Mendoza is the manager of advocacy and community organizing at the Anti-Recidivism Coalition. Prior to working at ARC, Kent worked at the LA Area Chamber of Commerce on smart justice issues. He was appointed to California's State Advisory Committee on Juvenile Justice and Delinquency Prevention in November 2016. He held several positions at the Los Angeles Area Chamber of Commerce from 2014 to 2016, including Senior Administrative Assistant, and Intern. While working at the Chamber on smart justice issues, he successfully completed the 2015 Commission Training Program offered by the Wally Mark Leadership Institute from Liberty Hill Foundation. Kent is also the spokesperson for the Campaign for Youth Justice, based out of Washington, D.C. Kent was appointed to serve as community representative for the 5th Supervisorial District to the Los Angeles County-wide Juvenile Justice Coordinated Council in 2018 and was reappointed in 2020. Kent was also selected as an Aspen Institute Ricardo Salinas Scholar in 2018. Most recently, Kent was hired as a consultant by the Burns Institute to work on LA County's Youth Justice Work Group, which is designing the moving of all youth out of the county's probation department completely. Martesha Johnson is the elected Nashville Metropolitan Public Defender, the first African-American to be elected to this position. She has a heart for serving people and was determined to be a public defender since interning with the Nashville Public Defender's Office in 2007. She has devoted her entire career to public defense work, her dedication fueled by watching firsthand the many injustices experienced by poor and marginalized individuals in the criminal legal system. Martesha interned with the Knoxville Public Defender Community Law Office and volunteered at the Nashville office after graduation in 2008. Martesha was officially hired in 2009 and served in many leadership roles during her tenure in the office. Prior to her election, she was the training director and member of the Special Litigation Unit, primarily focusing on serious felony representation. Martesha currently teaches trial advocacy at Vanderbilt Law School. Welcome all, and thanks so much for joining us. I'd like to start this conversation by asking Ms. Johnson to sort of frame the landscape for us. How do you view diversion as a tool in the broader movement of decarceration and criminal justice? And how do you think the conversation around diversion has changed in the last few years?
Thank you so much for the opportunity to be here and to speak about the topic. I think that diversion is certainly a very important topic of discussion these days. And the reasoning behind that is many people are becoming more invested in creating a criminal legal system that includes more efforts to reform and decarcerate and minimize the number of people that we are sending into the prison systems across the country. And so as we start to talk about how we reimagine and reframe the criminal justice system, diversion has become a topic of that, looking at focusing on programs and efforts and initiatives that will address the harm that may have been caused in these cases, but also looks to eliminate people from having the long-term consequences of having a criminal record, having the collateral effects of that sometimes span many years after they have experienced that initial encounter with the legal system. And so I think that in any effort that we can make as practitioners and stakeholders and leaders in the criminal legal system to really focus on efforts to eliminate mass incarceration and some of the other disparities that exist in the criminal legal system, then we should do that. And diversion is one of those efforts, one of those topics that we have been talking about as a legal community, but also should be focusing on. And I think that that is what many people are doing across the country. And so happy to talk about that. The landscape, I think, we've seen diversion a long time ago. This is not the first time we've sort of started to talk about diversion, but our efforts around the legal system and how we viewed public safety sort of changed. And we went through an era of tough on crime, and diversion started to be a less utilized method of moving people out of the system. And so now, as I said, with the renewed calls for reform and renewed efforts towards reimagining our legal system, diversion is certainly a hot topic, and one we should discuss.
Thank you so much. That's a really helpful framing. I'd like to turn to you, DA McCann. So in 2018, you expanded your office's successful juvenile diversion program into an adult diversion program in an effort to sort of expand the population of people who are eligible for diversion in your jurisdiction. Can you tell us about the process of expanding the program, and how did you decide on eligibility criteria?
So when I started as the DA, we already had a juvenile diversion program, but we see a lot of criminal behavior between the ages of 18 and 26. And it didn't make sense to me that we wouldn't have a diversion option for people in that age bracket. And so I was successful, thankfully, in getting some funding to help get a young adult diversion program started. And I really wanted to do this as a pre-file program. We'd never done a pre-file program in Denver, and really very few in the whole state have done pre-file diversion programs. The reason that was important to me was that if you do it pre-file, there's no actual filing of the case. So there doesn't have to be a plea, there doesn't have to be a guilty plea, or even a deferred kind of plea where you enter a plea and then you're on a deferred judgment is what we call it. You always end up though with that record of having been charged with a crime. So I did not know if we would be able to get the police department to understand and go along with this pre-filing idea. But fortunately, I had someone who was very supportive that was willing to head this up and get this effort going. So she worked with the police department. So the detectives are sent a notice immediately when we think a case is potentially diversion eligible. So they're told not to actually file the case. And then we go through a process of determining if someone should be eligible. So the kinds of things we look at are the nature of the crime. We're primarily looking at lower level crimes, although we are now in a pretty intense discussion about expanding to domestic violence. There was some resistance to that. So we didn't address domestic violence cases or sex assault cases in the beginning. And so we looked at lower level crimes and people who do not have extensive criminal histories. We do take people who have prior offenses and people who were willing to acknowledge and accept responsibility for what they did. And so the criteria are pretty minimal. I mean, we look at, my concept is to be as inclusive as we are comfortable with. So I have a diversion person who heads up our diversion program for juveniles, also heads up our young adult diversion. So her staff will go and review all the potential cases as they come in, make a decision about whether the person might be eligible, send the letter to the detective, and then there's a follow-up interview process to determine, the factors of whether or not the person's willing to admit responsibility, and are they really interested in doing diversion. Because diversion, despite the common perception, diversion is actually a harder program than our probation department generally, because they have more requirements in terms of meeting with the probation officer. They may have to get treatment and they may have to do community service. And so the person has to be amenable to it. And then they get into, when they get into the program, they're assigned a a diversion case manager, if you will, that develops the plan for that diversion program. So it's been quite successful overall. We've been very happy with the program, and we're now in the process of expanding it to all adults, not just that age group. And also trying to look at more serious cases, like I mentioned, the domestic violence, potential for some domestic violence cases to be considered. So I'm sort of rambling here now.
Thank you so much. That's really helpful. And I definitely like to circle back to, how you were able to cultivate the buy-in with other stakeholders to get that established. But, you mentioned how difficult it actually is to complete a successful diversion program. But I'd love to turn to Mr. Mendoza and ask, what do you think makes a successful diversion program? And, when setting something up like DA McCann was just describing, what do you think are the key considerations that prosecutors should take into account when setting up their program?
Yeah. Well, I mean, first of all, I would say that a successful diversion program, I would say, is one that doesn't have no system involvement, no probation, no law enforcement, none of that. However, that's an aspirational thing for now because there's legal impediments to get in there. But I would say that a successful diversion program is one that really really like looks at the kids at an individual case by case you know type of way because every kid is different with different traumas, different they ended up in that position because of what they did, but there's things that led up to why they did those things. So one that really understands what's going on, really looks back into that background, engages with not only the system players but people within the community to really understand the youth, to really come with real healing and transformation for the youth and ultimately for the victim too. But I would say like the main things that the key considerations the prosecutor should consider when making and looking to create a program, I would first of all, I would think that as someone who's been incarcerated, spent 5 years in jail from 15 to 20, I was tried as an adult. I was facing 25 to life as a juvenile. I know what it is to go through that experience. I could have been diverted at the age of 15, but none of that was in place, right? So I would think that things that need to be considered is, I would say that any diversion program shouldn't be run by any prosecutor office. It should be run by community. I think that the community really understands these kids. The communities are the ones that are in the communities where the crimes are happening, even where the victims are living in. So I would say that really engaging with stakeholders, community, people in the community to really understand what works and what doesn't. Obviously, there has to be, DAs have to be involved because they're part of the system, and but I would say that really engaging with the community. There's a lot of organizations, at least speaking from California and LA, there's a lot of organizations out in the community that probably don't fall under diversion or are not categorized as diversion, but there's a lot of services that if they were to be expanded, they can serve as diversion. So just making sure that prosecutors' offices are really engaging the communities and learning from them to really figure out what really works for the kids, and also stop charging kids. There's a lot of things that the DAs can do to avoid that from happening. So just committing to different principles and values of not punishment but actually real restoration and healing. I think that the challenge that I see is also in with the system players and the communities, that sometimes it's hard for people to see that yes, these kids, even if our brain doesn't fully develop until we're 26, 25, right? Even if a kid did do that thing or that crime at the age of 16, 17, 18, 19, we still have to remember they are still young kids that are going through youth developmental things, right? Their mind is still developing. So we have to meet that there, because if we don't, that's where you have recidivism. That's where you have people that go into diversion programs and it fails because we are giving them the things that we think they need because of the crime, because of their background, but not because of the things that we're asking them they need. And look at what they need, look at their competencies, what they really need, and really build off that. And that truly leads to real public safety, real transformation, and ultimately more savings of money. So just key consideration is just making sure that the community is involved, that it's community led, and if there is going to be some type of management, that is all grassroots. Because like I said, all of these kids, they come from the communities, and the only people that can really address those issues are people from the community where they come from. And I was also rambling, so I hope that answered like the main question.
No, thank you so much, Mr. Mendoza. That really wonderful. And you mentioned in your answer that prosecutors should develop some sort of understanding of the way trauma impacts the whole criminal justice system. And I would just like to point out the IIP actually just released a trauma-informed prosecution training about a month ago, and certainly that's a resource that I think folks can look to help sort of inform some of that understanding.
And one quick thing, just quick, I don't want to take too much, but another thing that I've seen is that I understand that we have to look at public safety and security, and especially for those that go in for serious crimes like murder, and those crimes that are I think that a lot of the concern is like to keep the public safety and security while they're getting incarcerated. I would say that also challenging ourselves as as the prosecutors or people that work in these offices, to challenge themselves to not look at behavior or changing that behavior as time and length. Like it doesn't equate time and length. Like it's all about opportunity and growth and development and healing. You know, I think that that's a very hard way to look at it, that we think that because they did that, they have to do this 1 year here or this 2 year here, versus they need this to grow and change. You know, I think that that's something that we need to start changing the narrative around, and just the conversation around what does really rehabilitation and healing community look like versus punishment and all that, and time versus actual healing.
Thank you so much. And we'll definitely circle back to sort of community engagement and DA McCann. I know you've been intimately involved in working with your community, but I'd like to turn to Ms. Oliva and ask you a brief question about your recent work with the IIP on diversion. So you recently co-authored a piece with DA McCann, actually, and Professor Ron Wright on office culture and diversion. What do you think the biggest challenges DAs face introducing diversion programs into their offices? And what are some of the best strategies to overcome those challenges?
Sure. Well, first I wanted to say thank you for having me, and thank you for inviting me to have co-authored the piece. When we were looking at prosecution offices and diversion programs, you know, we were focused on office culture and the challenges there. And the piece talked about or identified sort of three, I guess, potential pitfall areas. And I think the one that I would want to focus on here today is basically just the challenge of getting the buy-in from within the office, because obviously if these are prosecution-led diversion programs, you're going to need obviously the folks in the office to be committed to the program, because the program rises or falls, you know, on the backs of the ADAs who are administering them. And I think that, you know, regardless of who gets access to the program, meaning, you know, the people the office is charged, you're always going to need buy-in. And I think that's the biggest sort of hurdle that offices have to account for, you know, whether they're in rural areas, whether they're in urban jurisdictions, big or small. There is, I think, this phenomenon that crops up, especially in what's become known as the progressive prosecutor movement, right? Where you have progressive prosecutors who get elected, and that doesn't necessarily mean that the elected prosecutor necessarily is perfectly aligned with the people who are in the office, especially those who find themselves in middle management or mid-level supervisory positions, who you might ordinarily look to become office leaders. And so I think that buy-in is a big hurdle, whether you're talking about diversion programs or other reforms and policy changes that a so-called progressive prosecutor might want to make. So definitely you need to make sure that you're going to be able to get buy-in, and that can be a difficult thing because maybe you don't know how to take the office temperature, you don't know what the office temperature is. And so one of the things that we talked about in the piece was that you need to do the best you can to talk to the ADAs and the mid-level supervisors before you unveil or roll out, you know, whatever diversion program you have in mind, just so that you can identify before you start any potential pitfalls. And so, you know, I think DA McCann can talk about this better than I can, but, you know, I think in the paper, we talked a lot about the fact that it was easy to sort of start with juvenile diversion because there was an appetite in the office, a near uniform agreement that they should be diverting juveniles out of the system. And then from there, you build on success. So that, you know, buy-in, I think, is the big challenge here. And I think from the perspective, again, of looking at prosecution offices and the cultural challenges, I think the two sort of big strategies that I think you can employ are, one, you have to commit to the staffing of the program. You know, I don't want to just belabor what we said in the paper, but you need to find somebody who's obviously respected in the office, because I think, you know, anytime there's large change, people are going to be looking to sort of the symbolic actions and decisions that the elected official makes. And so you can make or break a program, but depending on who you staff in the program. And ideally it would be someone, again, who has a lot of experience in the office, who understands how the office works, but who's also well respected both within the office and then, you know, outside the office by defense counsel and by the courts, because obviously diversion requires partnerships and communication across a broad range of other systems actors. You know, we pointed out that perhaps there's something to be said for promoting someone within the office But then we try to analogize also and ask and encourage prosecutors to think about sort of the analog that people find in the conviction integrity world, where there's something to be said for hiring an outsider to take a fresh look at this. And I think that is something that shouldn't be underestimated in the world of diversion, especially if, to sort of echo what Martesha and Kent have said, like, if what we're trying to do is not just sort of recreate net widening, and if what we are trying to do is do something really different than, you know, quote unquote traditional case processing, there's something to be said for someone with an outsider's perspective. But regardless, I think staffing is a huge, huge deal. You can't staff it with someone who is not respected, because that sends an immediate signal to the line assistants that this isn't something that, you know, the head takes seriously. You also run the risk of creating a gap in messaging, especially if you've run on a progressive platform and you've publicly and externally stated to your community that this matters to you, and then you take an action that obviously undermines that. That's going to create another culture change issue and a cultural problem within the office. And I think what goes hand in hand with the staffing issue is obviously the communication. I think I talked about that and trying to take the temperature of the office and talk to the office before you unveil. But once the program, you know, is undergoing development and then is unveiled, you know, the elected needs to model commitment to the program, right? And that means not just publicizing it to the community, but also talking about it within the office and trying to tie it directly to the office's larger mission. And then also trying to understand who you're speaking to. So it could be that there are younger ADAs, let's say, that are committed, and maybe they joined the office specifically because they were taken by the messaging that, you know, a newly elected progressive prosecutor ran on. But you also have to understand that there are folks in the office who maybe feel threatened by the notion that the old way, or, you know, the traditional way of doing things, which is how they were brought up, they might feel like they're being attacked there. And I think that there are different ways to model the message. I think you need to know who you're speaking with. And I think this also ties into sort of the other papers that the IAP put out about data. I think that if you are able to, and I understand that not every office can, but to the extent that there's data available, and if you have access to it, you know, you can start with understanding your baseline. So if you're going to start with just a misdemeanor or a juvenile diversion program, you might want to understand just baseline what your numbers are and talk to them about the number of cases and what it means to be able to divert these cases out of the system, so that perhaps you can prioritize limited resources and move them elsewhere. But these are all the ways in which I think data and then the communications aspect together can sort of try to blunt or at least work on getting buy-in in the office and addressing any unique or, you know, individual cultural issues that a given prosecutor's office will have.
Thank you so much. That's really helpful and insightful answer. I'd next like to turn to the relationship between sort of an elected official and the defense bar in terms of building successful diversion programs. So Ms. Johnson, I'd love to start from you and, you know, hear a little bit of your thoughts on how prosecutors and defense attorneys can work together to ensure successful outcomes for participants in diversion programs.
Sure, and in Nashville, I am one of very few across the country elected public defender as well. So I understand the nuances of the election process and buy-in and all of that. But I think many of my sentiments are probably similar to those of Kent. I think that the relationship with the DA and the defense bar, you know, obviously as a defense attorney, I am invested in programming and things and options that will remove my client from the traditional legal path. And as a public defender, let me nuance that a little bit more. I am particularly interested in those options for my clients who are poor and already marginalized. And so one thing I think for me is to keep our focus on the bigger picture of how we remove more people from the traditional criminal legal process in hopes that we are creating a better society as a whole with benefits for the person who has been charged and also the people who have had the harm happen to them. And if that is our goal, then I think having these programs that operate in a way with an eye towards restoration and an eye towards community building and an eye towards healing is a different process than an eye towards this is a gift that we're giving the defendant in this case, and we operated in that fashion, or it's just another form of real punishment. Some diversion programs that can fall into sort of the cycle of we reincarcerate little by little. And what I mean by that is there are some programs that you are diverted for a year or longer period of time, and you have to come into the courts for status updates and checking in with your community provider and your probation officer. And there are times where a person who has deviated from the program goals can find themselves sanctioned or serving smaller bits of sentences, even though they're in a diversion related program. And so I think that making sure that we have the right goal in mind and recognizing that with the discretion and the power that the prosecutor has, this is a good thing. But also I think making sure that we're keeping an eye, and I think data would be important there, towards deciding and determining who is eligible for these diversion programs, making sure we're not opening the door for disparities and in figuring out who we deem worthy enough for getting diversion, participating in these programs, and making sure also that a big piece of that for me is community and making sure we're creating avenues for that person to remain a part of the community and society rather than just making it a longer process for incarceration or continued punishment down the road.
Thank you so much. And DA McCann, I would love to hear sort of your thoughts on working with the defense community in your jurisdiction. Oh, you're muted, DA McCann.
Sorry. The defense community in Denver has been very supportive of alternatives to the traditional criminal justice system. And so I think particularly the pre-file idea, so that people don't end up with a conviction on their record or actually a charge. So we work with them in terms of clients that are eligible. They can suggest clients that they think are eligible. One of the things that I didn't talk about that I also started last year was a restorative justice program for our adult population. And we did a lot of stakeholder meetings and so forth before we started that program. And that in that program, we do, defense attorneys again can suggest that their client would be appropriate for a restorative justice program. They're kind of two separate programs, which is probably not so common because they can easily be combined, but I was able to get the ability to hire someone to head up our restorative justice program. And Courtney is absolutely right. The staffing is really critical because if you don't have someone who is really dedicated to making sure the program works as their full-time job, it's very easy for it to get off track. And that has been just a godsend for our restorative justice program because we have one person who did a lot of that legwork with the stakeholders, and she has a counterpart in the public defender's office, so they communicate all the time. They actually do trainings together about restorative justice because some of the public defenders are skeptical about restorative justice also. And so education is really important. And we have to educate the judges about what this program is and how is it going to work. And our own office, and educating our own office as well is part of that so that our attorneys can communicate with the defense bar about different options that we have.
Michael, just if I could really quickly, I didn't speak directly to the Nashville sort of system, and it's very similar to what DA McCann is describing in her jurisdiction. We do staff many of our diversion programs with our counterpart in the district attorney's office. And so we do have people who have dedicated, in addition to their other docket requirements and caseloads, but they have dedicated themselves to the various restorative justice in Nashville. That program is right now only the juvenile side. We also have other programs that address various things, mental illness and trafficking and all types of things that we, as a part of those diversion programs, we are sending a dedicated staff member to that program. And they do become kind of the liaison for our office in terms of education, in terms of referrals, in terms of, you know, making sure that we understand the program thrust, but also that we make sure that we have our clients' voices heard in those processes. And so that I do think is critical, even on our side, that you have the appropriate staff who is staffing those courts and those programs to make sure that it works successfully.
Thank you. And Ms. Oliva, just turning to you on the next one. How do you view the future of diversion programs, and where do you think it sort of fits in as a major piece towards reducing the crisis of mass incarceration? There's you know, a bit of pushback from some folks that it's really just a net widening tool and doesn't go far enough in terms of getting the root causes of mass incarceration. And would love to hear sort of your view on that, and then open it up to any thoughts from any of the other panelists.
Yeah, I mean, I guess I would say that I think that having a diversion program in theory, or having diversion programs in theory, I think are necessary, but definitely not sufficient components to reducing mass incarceration. I mean, I think that Martesha and Ken are right, that there are, you know, underlying or other root causes that can be and should be, I think, addressed as much as possible in communities, and that it, you know, if we were to sit here and say that prosecutors are the place to start, I'd say that's wrong. So in that respect, I don't want to suggest or be seen as endorsing an idea that prosecutors are going to save us or save the system. But with that said, I think that diversion is a beginning point, because it helps us recognize that for a long time, and still today, I think many prosecutors are not necessarily doing all they can to sort of thwart the harm of the system. And so I think diversion, when I say it's necessary, is a necessary component, because it begins the process of having a dialogue within the office also about whether or not the cases that they accept for prosecution are really cases that should be in the system at all. And it allows, I think, a starting point to have a discussion about whether and how and what prosecutors should be doing and what their roles are. So I guess I would say that that's why it's sort of a necessary but not sufficient component. I share Martesha and Ken's concerns about net widening, and I think this was not addressed, I think, in our paper, because we were talking specifically about prosecutors' offices and cultural change. But I think that the reason why I say that in theory they're useful is that I think the design of the program is where I think the pitfalls exist. I know that, as an example, Brooklyn has a successful mental health profile, and they actually started more serious felonies, if you will, to put that in quotes, because I think that their words. And I think that there is research to support this idea that for people who are not necessarily at high risk of offending again, having repeated contacts with the system can actually be worse for them. And so to the extent that you have long periods of supervision in a pretrial diversion program, that actually might be doing more harm than good. And so I think that if there's going to be success in chipping away at the crisis of mass incarceration, at least at the front end through diversion, I think prosecutors who want to design their own diversion programs need to involve outsiders and folks who are experts in the field to try to bring evidence-based practices to bear and to ensure, right, that the whatever modalities of treatment are being sought and designed in these diversion programs are treatment modalities that are, you know, appropriate for the people who they want to admit into these programs. And I think, you know, again, I guess I would say that it's necessary but not sufficient, because it really is obviously only the front end. And, you know, this is a panel about the front end, but there's obviously, right, another issue at the back end, which is just relieving the total number of people who are in prison. And obviously diversion doesn't necessarily have much to say about those people serving those long sentences. It does, though, I think, speak to, I think, the future or the success or the failure of diversion programs if they continue to only sort of target people based on classification of offenses. I'm not sure that you'll see much in the way of sort of chipping away at mass incarceration if you think that mass incarceration is also an attitude. In other words, if you think that what we should be doing is continually offering chances to people with no criminal record or people who are only charged with misdemeanor offenses, and that we continue to be okay with throwing the book at or being extremely punitive towards people who are charged with serious offenses, I think if you continue to break diversion programs down along those lines, then we're not necessarily going to see any sort of attitudinal adjustment that we might want to see if we're going to be able to sort of chip away at mass incarceration as something that's sort of like a mindset as opposed to just sheer, total number of people in prison. So I think that, again, just to circle back, in theory, I definitely think that they have a place in the system. I think that prosecutors, if they tread carefully and don't engage in net widening and speak with outside experts to ensure that the net widening doesn't happen, and that if they are appropriately tailoring the interventions the way they should based on these evidence-based practices, I think that there can be a future, and it definitely can help move us away from mass incarceration. But I don't think it's by any means like a global panacea.
Thank you very much. Does anyone else want to chime in on that? Right, if not, then I'd love to turn to you, Mr. Mendoza, and ask you to speak a little bit about your work with the Anti-Recidivism Coalition and sort of the ways that you've seen diversion work into your ultimate mission.
Yeah, I feel like I could say a lot based on everything that's talking or you guys have said. I think it's an amazing answer. But when ARC was founded, it was founded in 2013. However, our founder had been doing in-reach, going inside juvenile halls, meeting the kids that are currently facing sentences and all that, going through all that in 2003 all the way to now. The reason I'm trying to say this story is because what he was intentionally doing, it was kind of like diversion work, He was meeting the kids while they were incarcerated, while they were being charged with serious offenses, some of them facing 20, 50, 60 years to life, and they're 14, 15, 16-year-old kids. And, the way we talk about diversion, I think that also matters. I think that in LA County, when we were trying to, when we have an Office of Youth Diversion and Development, but when we were trying to get it open, before it was going to be just the Office of Youth Diversion. But the community, because we kept showing up and saying, no, this has to be an Office of Youth Diversion and Development, YDD, because it's not about just diversion, it's development. We're talking about, like, it goes again to the same thing. We're talking about kids that are still growing up, kids that are still creating developmental thoughts. Their mind is still growing in like a plant, right? So the reason why we want to make sure that it's also, this is really considered, because if we're trying to put a kid into a program or into anything, we gotta know we gotta know everything about the kid. And going back to ARC, and what I was saying is that ARC was, followed the kids, and now we have a lot of young people that come home from after doing 5 years. So, it's not really diversion work what we're doing, but it kind of is, because when they're at our programs, when they're living at our house, and we have 2 housing locations, and something happens there, if it was a program that was run by probation or by someone with the systems, that little mistake probably could have become a violation or something that eventually leads to like the whole thing of net widening, just keeping them in that system. So I think what we do at ARC is just really support people who've been incarcerated by people who've been incarcerated. So I think that's what makes it effective. Formerly incarcerated people supporting other formerly incarcerated individuals, and not only supporting when they come home, but we're actually meeting them while they're doing their sentence, and even before, when they're getting arrested, when they get locked up, and they're barely they're going through a legal process, we're meeting them there. So I would say that, what we are doing is just really meeting the individuals as a human beings and really understanding them, and I think that what will help this discussion, or just like, we really need to include voices of system impacted individuals in this, in all of this, because, you know, oftentimes the only people that engage with these individuals are system players, but it's never nobody from the community. It's never nobody that really can engage with them and really understand what they're going through. So, you know, at ARC, we are, you know, we believe that, you know, we are member driven. We believe that people who've been incarcerated can, you know, we can be the best mentors for that population themselves. You know, we, you know, it's just one more example. When you know, I have 4 interns right now that work under me. All of my interns just got out of jail. They got out after doing 5 years. One of my young interns, she's 20 something. She just got out after doing 10 years. She was in from the age of 12 all the way to 22. You know, that's a long time of incarceration. She should have never done those 10 years, you know? So now she's working with me. She's my intern, you know? So what I'm trying to say is, like, that's a diversion to me when you give them real opportunity to, you know, be part of changing the system. So what I'm saying is, like, maybe also having prosecutors start hiring people that are formerly incarcerated. Let them guide you on how you're gonna make the decisions, or, you know, or do collaborative team filing. I don't know, make, you know, like, be more inclusive. So I guess that's just something I wanted to throw out there. But other than that, at ARC, we work with a lot of people who've already done their time and sentences. A lot of people who went in when they were teenagers and they're getting out when they're 40, 30. So a lot of our members are getting out when they already did their time, but they went in when they were young. But we do have a lot of young people who got out of juvenile prisons who are, I work with a lot. So, you know, really what works is just, you know, really diversion starts from the day they get arrested all the way, you know, different points of contact with the law enforcement. So just making sure that, you know, they have that support throughout the whole time. And that's what really is gonna get them to really change eventually. So yeah, and sorry for going all over the place, but that's my answer.
Thank you so much. I really appreciate that. I mean, you know, support for those who have recently gotten out is obviously an incredibly important issue, especially at this time, you know, when we've had an opportunity to get so many people out and figure out ways that, you know, we can support our re-entering citizens. So thank you so much for bringing that up. I'd like to, you know, open this question to anyone who wants to take it, but how do you think we should be measuring the efficacy of a diversion program and figure out whether or not it's something that should be optimized for scalability? I think that, you know, figuring out whether or not something's effective has been top of mind for folks, and I would love any thoughts that the panelists have on that topic.
Well, I think traditionally we've always looked at recidivism. I mean, that's just the way that we measure these things and have traditionally. But what we're trying to do with our adult diversion program is actually do kind of a follow-up with the person after a certain number of, like, a year or 3 years, to see, you know, have they gotten a job or have they completed whatever their goal was in terms of education, so that we can have a little bit broader view as to whether or not the program is successful. Certainly not having more criminal involvement is a success. But, you know, if we can help them find a way to move forward in their life and measure that, I think that would be really helpful for us to see if what we're doing is actually making an impact.
I agree with that. And I actually really like the concept of checking in with the person who has participated in the program to allow their input on whether it made an impact. I think that is important. And I do agree that oftentimes we measure success based on recidivism and based on whether or not a person has had any further contacts with the legal system. But I think as we think about what our goals are, then we're really talking about programs that transform the way we think about the criminal legal system, the way we think about public safety, the way we think about what should be incarcerated, all of those things. So measuring programs have to include components of all of that. Have we successfully included community buy-in? Have we made agencies that are already working in communities with clients and families, have we made them a part of the concepts? Have we made them a part of the process? Have we made the program itself conducive to setting someone up for success after they leave the program? And what does that success look like? What are they able to do as a result? Or are we only caring about them for the time period which they're participating in the diversion, and then after that, the support is gone? And most importantly, are we using these programs as a method and a tool to advocate for larger scale changes that will affect the communities and the people before they ever make it to the criminal legal system? So much of what we can do, because all of these things are connected, involve repairing other systems that contribute to people going down the path, I would say, of having an encounter with the legal system. So I would say leveraging our program success to then in turn advocate for successes and advocate for changes in other areas that marginalize people, that reinforce poverty, that do not address trauma and mental illness and addiction. I think those are important measures of success if we're able to do all of that.
Thank you. And just one quick follow-up on that. I mean, anyone can take this. What do you sort of think of as best practices for, on the front end of working with a community before establishing a diversion program? If you were a prosecutor looking to build out a diversion program in your own office, sort of what would your plan be for sort of seeking community feedback and incorporating that into your program?
So I'm certainly not a prosecutor trying to bring that into my office, but I do think before you engage in any sort of community relationship at all, your perspective can't be that you are coming in to sort of save a group of people or that community, or to minimize the work that community organization or community group has already been doing in the area. I think, as Kent said earlier, most of these community agencies and organizations, they know the people that are involved in the process. And so they're really the experts to help us. And really including them as such is important. That's the first step before you just enter the community to give information. It's probably listening to the needs of the community, but the group that you're going to be working with specifically, and trying to figure out a way to collaborate and not kind of, I guess, put your views out there as if they are the only views to have.
Thank you very much. And we actually have quite a number of questions that are coming in from the audience. So I'd like to get to a few of those before we're out of time. And this question is from Ms. Johnson and DA McCann. In your offices, what types of offenses do you offer restorative justice options for? And what does the commitment typically look like for participants?
So we started, because this was new for my office, for our adult program, we started with misdemeanors, and that was deliberate on my part because I wanted to get the buy-in from the attorneys and the victim advocates. And I felt that that would be more successful by starting at the misdemeanor level. So my county court deputies will eventually be promoted to our felony level. And if they are believers, in the beginning with their misdemeanor cases, as they move up into the office hierarchy, I guess, they will carry that with them. And also, I wanted to have some success stories so that we could display those to the rest of the office, which we now have because we've been in operation. It started last October. And as a matter of fact, we just had a big training yesterday for the entire office on restorative justice, and put up the statistics and put up testimonials, if you will, from some of the county court deputies, as well as the chief deputy for county court, talking about their experience with restorative justice, because we are now expanding into felonies, or that's my goal. We will be expanding into felonies. And as I mentioned before, we are also taking domestic violence cases now and child abuse cases. And we've had the one sexual contact case. So my goal is to not have boundaries necessarily. I mean, I don't think we'll be doing this in, murder cases, but to have the ability for the deputies to have discretion and be flexible and look at cases. One of the things that I made a conscious decision to do in the restorative justice program, which is not the case with all restorative justice programs, is to make it a condition that the victim agrees that the case will go through that process, whether or not the victim actually wants to participate, which we want them to. But we decided that, again, to get buy-in from our victim advocates, it would be important to have the victim involved in making the decision about restorative justice. That's not true with our diversion program, but we're going to see how that works. So far it's worked fine, but it may be that we have a case where a victim doesn't want to do it and we believe that it should go through restorative justice. That'll be more challenging for us, but I know our experts in restorative justice here in Colorado do not think that getting the agreement of the victim should be a condition. I chose to go a different way just because I know getting buy-in from victim advocates is going to be very difficult. So.
Nashville's process is similar. Our DA, our restorative court or our restorative practices right now are only in our juvenile system, but the process is similar in terms of having to have the buy-in of both the juvenile who has been charged with the harm and also the person, the victim of the offense. And our efforts here have only extended themselves to a certain number of property offenses. They have not expanded very largely into other areas at this point, though we are now into year 2 of the program, and I think that expansion is what is next for us to discuss, and also a potential expansion into the adult side. But that is where we are right now with just our juvenile courts handling restorative practices.
Thank you very much. And another question from the audience is on the topic of addressing issues concerning diversion and racial disparities. So one thing we know about diversion programs is, ones that typically have sort of a lot of front-end restrictions tend to, even if they're facially neutral restrictions, tend to sweep up a lot of things that we know drive huge racial disparities in the system. So that could be prior police involvement, arrests, gaps in the system. So I'd love to hear from, any of our panelists who, can speak to what best practices are for being mindful of widening the gap of racial disparities in the system when creating a diversion program.
Well, we were very conscious of that. And our data is, we keep our racial data and ethnic data. Our data is, we actually have a higher percentage of people of color in the diversion program based on our population in Denver than we do Caucasian. And I've been very clear with the woman who heads our diversion, who happens to be Black, about the need to make sure that this isn't just something that's offered to the white defendants, but that it gets offered to everyone. We're kind of lucky because we've set the program so we have discretion in terms of a prior record, because I do think that prior criminal history does have a discriminatory effect. So we do not disqualify people just because they have prior criminal history. So I think that's helped in our program.
Thank you. And then one final question before we wrap up. From the audience, I'd love to know how folks have found the reception to diversion programs and sort of buy-in from other stakeholders, whether that's judges or community members, in the wake of the COVID pandemic and the push for decarcerations that sort of changed the attitude of many of the people you work with or conversations you've had about diversion programs.
Well, I'll just start. Also, I hate to dominate, but I don't think COVID has impacted our ability to get people into diversion, or, our courts are continuing to operate virtually and our diversion program is continuing to operate mostly virtually, but we're starting some personal visits now. And so we've continued the program. What has been interesting just recently is, this is not COVID, but something that has impacted is the recent protests in Denver, because I just had a conversation yesterday, I think, with the police chief about the police department not wanting us to divert people who've been damaging property and breaking windows, pulling down statues. There are some young people who've been involved in that kind of behavior who we would normally at least look at for diversion. So, and my police chief has been very supportive generally of restorative justice and diversion. But it's interesting that it's coming up in this context. And I get it. I get where they're coming from, because they, you know, the traditional police approach is we don't want what happened in Seattle or Portland to happen in Denver. And so we need to be tough on these people who are breaking windows and causing damage, property damage mostly. And so we've had a conversation about that. I've told him that we will look at the cases and be judicious, but I also respect that from the police perspective, they believe that the message it would send if these young people get diversion is that we don't value the police, you know, we're not supporting the police. So it's a balancing act. I mean, I need to say that the kids, the young people that we're talking about so far are white young people who don't seem to have a lot of commitment to the cause, but are actually seem to be more interested in breaking windows. So it's just been interesting having these discussions in this context versus the COVID. I haven't really seen an impact necessarily from COVID, except that we are releasing a lot of people from jail. We're agreeing to PR bonds and things of that nature, but it isn't really impacting diversion.
I could add a little bit to that.
Thank you.
Sorry about that if I jump off. I know that in LA County, the board of supervisors put a motion to respond to, you know, to keep the youth incarceration population low post-COVID-19 and decrease post-COVID-19. And I've been working closely with public defenders myself, you know, in a resource tool, collaborator tool spreadsheet where, you know, they could use to share with the clients. But based on what the discussion has been going on with the prosecutors around this is that the plan that came back, the plan they submitted was probation and the Youth Diversion and Development Plan. They provided a report based on that motion, and one of the things that probation is doing is they did it on their own, right? They went to the court and they got something where now they could be citing kids, and that citing the kids will get them into diversion programs. And to me, it's like, it's kind of not what we wanted, because it's like, now it's like you're just doing what the opposite, right? You're kind of just expanding that, your ability to put them in these programs, and it goes into the conversation around like, you know, I think Courtney said it, like diversion is good, it's necessary, but not all the time, because sometimes it just sometimes puts people in a system that you can't get out no more. And, you know, not every kid needs to be put in a diversion program. Just because you are going through whatever, that doesn't mean you have to be in a program, you know, like there's, you know, we have to avoid that. But, you know, the main conversation is going on around is, I think what I've been talking to prosecutors about is just this thing about time and punishment, this time and length and punishment. Like, it's just been around that. Like, it's been hard to get them to understand that at the end of the day, these are still young kids. And I feel like it's hard for some people to see past the crime. And I think that allows them to see that, hey, this kid can still change if you keep sending, you know, I feel like that's the conversation we've been having lately. And it's been very intense conversations, because, you know, as you know, in LA County, right now, we are currently literally meeting. We have met for the past year. You know, we're working on a plan and a report and a blueprint on a model of how are we going to move all of youth out of the probation department into another one of youth development and care and all of that. And that touches different systems, you know. And we also are already working on, the governor is going to close down the juvenile prisons in California, the state prisons. So now that means that each county is going to have to be responsible in addressing that, you know. So what does that mean? That means that, okay, if there's no juvenile prisons, those 707B, those serious offenses, where are they going to go now? Where are they going to stay? And how does that look like? So we've been having discussion, how would that look like? And the main around the prosecutors, we've been talking about just this thing around security. Like they have just concern around security. While these kids get locked up, where are they going to be at? and what does that look like, and what does really time and length look like for this individual? So that's what the conversation has been going around currently in LA County.
All right. Well, thank you so much. I really appreciate everyone's thoughts, and looks like we're out of time. Thank you so much, everyone, for joining us, and a special thank you to the panelists for lending us your time and expertise.
Thanks, everybody.
Thank you.
Thank you.
Thank you. Interesting.